this morning's docket. Case number 117862, Brenda L. Rosendahl, the Kansas Department of Revenue.
May it please the court. My name is Joanna Labastida, and I'm representing the Kansas Department of Revenue. If I may, I'd like to request 5 minutes rebuttal.
5 minutes is granted.
Thank you. Good morning. Just as a very brief factual background of this case, this is an administrative driver's license suspension appeal stemming from a DUI. The deputy in this case was dispatched to a one-car accident. The car had been driven into a ditch, and he encountered the petitioner, Brenda Rosendahl. He noticed clues of possible intoxication, and he asked her how much she had to drink that night, and she told him 1 beer hours ago. And so he continued on with his DUI investigation, eventually arresting her for DUI. At the administrative hearing and later at the appeal from that hearing, the trial de novo, the district court, Ms. Rosendahl claimed that after the accident, but prior to her encounter with the deputy, she had consumed close to 16 ounces of vodka. The district court in this case relied on Swank versus Kansas Department of Revenue to find that if there is any possible post-accident, pre-encounter intoxication, that the deputy had the duty to inquire. The Kansas Department of Revenue's argument is that the district court erred in finding that the officer in this case did not have reasonable grounds to request the evidentiary breath test.
Does the absence of an inquiry always nullify a subsequent test?
Your Honor, I would argue that it does not.
Okay, why?
The court.
It seems to me that's the position here, is that there was an absence of an inquiry, therefore it nullifies it.
Your Honor, I would argue for several reasons. In fact, this court in Swank held that a reasonable investigation must be completed by the officer, and that, in fact, reasonableness is key. The officer in this case encountered the single car accident. The explanation by Ms. Rosendahl was that she had missed her turn. It's a dark curve of the road, and he agreed it is a dark curve of the road. He was dispatched at 5:35, and he testified at this time of year it started getting dark around 5, so he assumed that the accident had just recently happened. When he encountered her, it's in in sort of an industrial part of town. So
should he have asked when the accident happened?
That might have helped his inquiry, or maybe would have helped this court determine if the investigation was more reasonable. But based on the other circumstances of the incident and his investigation that night, I don't think that is detrimental to this court.
That was reasonable for him not to ask that question.
I would agree, because
I'm not saying that, I'm asking.
No. Yes, I do. I would agree that I would argue that it wasn't necessary for his inquiry because of the explanation he received that she had missed her turn because of a dark turn in the road. And based on the circumstances that night, he assumed that it had recently happened. It was an industrial area of town. There were no bars or restaurants or even liquor stores in that town, or in that part of town. She didn't have an open container. She did smell of alcohol, which is why he initially asked her how much she had to drink, and she was very definitive in her statement that she had 1 beer several hours ago, and that's it. He relied on that statement to believe that she had consumed alcohol prior to the accident.
There seems to be, in the arguments, a lot of different variations about what the evidence might have been that would indicate she had left the scene and returned. From your standpoint, what is the evidence that best supports your position that the officer had no reason to believe she might have left? Or whatever your best argument would be on that point.
Right. I think it was reasonable for it was fairly clear that she had left the scene because when the officer arrived, they were pulling her vehicle out. It was a tow truck that was pulling her vehicle out. She told the officer that she had walked across the street to get someone to help her, and at the time that the officer arrived, they were helping her. But the amount of time that it would have taken for her to consume that 2 cups worth of vodka, I don't think it was reasonable for the officer to assume that she had consumed that much alcohol in that short of amount of time, based on her claim that it was a dark curve of the road that caused the accident in the first place, and that it had just recently become dark at that time of year. At the administrative hearing, at trial at least, Ms. Rosendahl again changed her story and claimed that it was a deer or something on the side of the road that made her jerk her wheel and go into the ditch.
But just to clarify my colleague's question, you acknowledge that the law enforcement officer knew at the scene that Ms. Rosendahl had left the scene of the accident prior to his arrival?
I honestly cannot remember if we went into that actual evidence at trial. As the court is aware, there was an incident with the transcript not recording, and so we had to come up with a statement of proceedings. But I would argue that even if, and I do believe that the officer had some inclination that she might have left the scene in order to get help, I don't believe that that is based on the part of town she was in and how long it would have taken her to go get help from the time of the accident to the dispatching him out. I don't think it was incumbent upon him to ask if she had consumed alcohol after the accident. Everything happened, from the officer's perspective, everything happened in such a short amount of time and in such an industrial part of town, why there was no reason for him to think that she would have consumed 16 ounces of vodka.
Let me ask another question you hit on, or factual question that you hit on earlier about had one beer a while ago, and that's all. I see conflicting accounts as to whether she definitively said that was all she had to drink. And what are you relying on for her saying that? The officer, I think, it said it 2 different ways at different times.
Well, a couple of different things. The officer, that was his testimony, is that she told him 1 beer. At trial, Ms. Rosendahl agreed that she never told him that she consumed such a large amount of vodka after the accident. She told him that she had had 1 beer as well. Her explanation...
But you understand what I'm talking about. It's different by, have you had anything to drink? Yeah, I had 1 beer and 16 ounces of vodka.
Right.
But versus, I had 1 beer and that's all I've had to drink. There's a big difference there, isn't there?
Your Honor, I believe the officer's testimony was pretty clear that she was definitive in her statement.
When was he clear?
He was clear at trial. I might not be understanding your question, but I believe he was fairly clear at trial that she was definitive in her statement that she had had 1 beer several hours ago, and that's it. And she agreed on her on cross-examination that she did not tell him that she had consumed that alcohol, that she did tell him she only had 1 beer. In fact, the judge also inquired, and she agreed that she never mentioned anything about the vodka until the administrative hearing.
And how quickly was the evidentiary blood alcohol content test taken after?
It was within the time limit, of the 3-hour time limit, but she did perform field sobriety tests at the scene. There was actually quite a bit of time at the scene where...
Well, let me cut to the chase.
Oh.
Was there any testimony as to rates of absorption or metabolism that if she did in fact drink 16 ounces of raspberry vodka at the body shop, how long it would have taken for that to have raised her blood alcohol content to 0.209?
There was not.
Okay.
Could you, you looked at the docket this morning. We have numerous cases that, regarding different issues that arise from this type of hearing and then get appealed de novo to the trial court. What could you articulate to me, or what you think the standard of review is for us, and then apply it to your set of facts, or what we have here?
Yes, Your Honor. The standard of review in this case is for this court to determine whether the district court's decision is supported by substantial competent evidence. I would, however, argue that...
Is this a bifurcated standard, and then we would reach the legal conclusion de novo, or is just where do you see, what is our role in determining the ultimate legal conclusion that's drawn from the facts?
Yes. So your duty, I guess, is to determine whether it's supported by substantial competent evidence, and then you must determine whether the evidence was such that a reasonable person would accept it as adequate to support a conclusion. However, I think the burden that the district court put on the officer to investigate, and I would argue overly investigate, into any post-accident consumption of alcohol, did not provide, Your Honor, if I may have a moment to gather my thoughts here.
That's okay. No, it's hard when you start to apply. That's my question.
Right.
And that's why I want to hear how you would apply the facts, our standard of review to your facts.
I think the district court in this case created a situation where the officer wasn't able to meet the district court's high burden of providing enough evidence for reasonable grounds, when really the officer at the time, it was very reasonable for his investigation to stop at his inquiry into her consumption that night. And based on what he had in front of him, it was substantial competent evidence for him to believe that he had enough reasonable grounds for this evidentiary test. One other issue that did come up at the district court was the thought that maybe Ms. Rosendahl should be equitably stopped from claiming later on that she had consumed such a large amount of alcohol. And the district court found that because this court in Swank, and actually the Court of Appeals as well, never addressed that, he wasn't going to as well. But Department of Revenue has raised that as a possibility for this court to determine that Ms. Rosendahl was equitably stopped from claiming such a new set of facts.
The trial judge indicated the facts are not in dispute, and I didn't see anything in the briefs that indicate that the facts are in dispute from what he heard. Do you agree with that?
I would agree with that except to the extent of what the officer knew that night.
Well, I understand that. He testified to what he knew. That's not in dispute. She testified later as to what happened. That's not in dispute. The question is reasonableness as to what the officer knew at the time and what he did at the time based on those observations.
That's right.
He didn't, there was no question here about asking about drinking or ignoring the drinking question. He said, "Have you had anything to drink tonight?" She answered, "Yes, 1 beer." And your argument is that should have ended the reasonableness test or observation. There was nothing more the officer could have done that night in order to then do what he did. Is that correct?
I would agree with that, except to the extent that the district court I think he overextended the Swank holding to say that if there was
I'm not talking about that. I'm talking about what the officer did.
Right. I do agree, based on the circumstances of that encounter that night and his investigation to that point, that there was nothing more he could have done to inquire into.
And based on what he observed at that time, it was reasonable for what he did.
Exactly.
They were reasonable grounds.
That is right.
Okay, thank you.
That's what my argument would be.
And you're, excuse me, counsel, and you're asking for us to apply equitable estoppel because if we said, well, why don't you just have the finder of fact find her testimony to be incredible, The problem with that is she had a corroborating witness, correct?
Yes, that is correct. She did have a witness come and testify on her behalf that he is the one that gave her the alcohol that night. And to put it that way, I suppose even if the court found her testimony to be credible and her corroborating witness testimony to be credible, that she should still be stopped from claiming this new theory at both the administrative hearing and the trial.
And as I understand your officer reasonableness conclusion, if it got dark around 5 o'clock and he was there, or at least received the dispatch call at 5:35, you believe it was reasonable for him to say in 35 minutes, how would she have been in this accident, walked someplace, got a tow truck, the tow truck came back, and during that time also consumed 16 ounces of vodka?
Yes, Your Honor, including the fact that it was in kind of an industrial part of town. I don't think it would be reasonable for him to assume that every business has access to a bottle of vodka.
And if a greater length of time had been involved, let's say an hour, instead of 35 minutes, does that increase the officer's inquiry responsibility?
I think it would, only to the extent that she claimed that she was in the accident because it got dark. And, you know, if he had been dispatched at 5:30 and she'd gotten into the accident at 4:30, it wasn't dark yet. So maybe...
Well, let's say that he got the dispatch call at 6, and she said it was just getting dark when I missed the curve. So there was an hour between the time the accident happened and he learned that during that hour she had gone someplace, got a tow truck, and that sort of thing. Does that increase his responsibility to inquire about what else she may have been doing, e.g. drinking vodka?
I do, Your Honor. I think that probably does increase his responsibility to inquire further. But the circumstances of this case would lend itself to think that she had not consumed alcohol after the accident. And one point that I did want to make before I finish is that it seemed that the district court in this case relied on the holding in Swink, but extended it to say if there's any chance of post-driving consumption of alcohol, they have to inquire, as opposed to what is reasonable for the officer to believe that night based on the circumstances. I am out of time. I know there's another issue, but I believe a few other cases on the docket also have that issue. If you'd like me to briefly summarize what the Department of Revenue's position is on that, I'm happy to do so. That is the district court in this case found that the statute that requires KDOR to charge a $50 administration fee, $50 fee to have the administrative hearing, he found that to be unconstitutional, but also moot in this case.
Counsel, since that is going to be coming up and it's generally not fair for you not to say anything about the issue and then wait for opposing counsel to, why don't you take 60 seconds to talk about the constitutionality issue, and that way you can elaborate on that during rebuttal.
Yes, Your Honor, thank you. First, we would argue that Ms. Rosendahl was not indigent in this case and therefore she lacked standing to complain about this fee as it's applied to indigent persons. We would also argue that that driving is not a fundamental right, and therefore it is not required for us to have a fee waiver for indigent persons. That's only when a fundamental right is at stake, and that even if this court finds that subsection of the statute to be unconstitutional as applied to indigent persons, the district court's holding was overly broad when he found that the statute is unconstitutional as a whole. Oh, and that is my very quick rendition of that issue. And
Do we have any more questions of counsel?
Real quick, you say that Mr. Rosendahl lacks standing, but I heard you say that the district court found that the unconstitutionality was moot, and that wasn't the basis for his determination, that the $50 fee was okay. So that, the unconstitutionality would be dictum, and why do you have a right to appeal dictum?
Well, that is a very good point, except that the court, I mean, that was their final decision, was that it is unconstitutional.
Well, if they decided the death penalty was unconstitutional, could you appeal that? I mean, if it wasn't a basis for the decision of the court, then how can you appeal that?
Well, Your Honor, I think based on the statutes that allow the state to appeal anytime a district court has found a statute to be unconstitutional, gives us that position.
Even if it's not the basis of the decision, even if it's dictum?
I believe so.
Okay.
Thank you.
Thank you, counsel.
Good morning. My name is Ronald Wood. I represent Brenda Rosendahl. Thank you for taking your time on this case. This is regarding driver's licenses, which are very important. The statutes have been changed in such a manner that they're taking driver's licenses are going from a year to 2 years of suspensions. I have clients telling me I'd rather do the time in jail if I can keep my license. That's how important it is to them. It gets to a situation where you have people without driver's licenses, they're trying to get to work, then they're getting picked up for driving on suspended, and we had this continued problem. So they're very important, the driver's licenses are. My client, Brenda Rosendahl, is not here today because of medical issues, but you can look as far as the facts in this case. She went into the ditch. She was in Osawatomie, Kansas, small town. She was close by an industrial area. I think she'd indicated that maybe her son had worked there, possibly a brother had worked there at an auto repair place. It wasn't that far from the actual ditch where she was. She indicated that she didn't have a phone on her and went to Masix to call to get some help in the vehicle. She went there. She indicated that she knew she wasn't going to be driving anymore because the car was going to be towed out of the ditch, and that 2 people were going to come and get the car. And she was offered from Masix this drinks. In her case, it was vodka. In the other case, I guess it was hot damn, I guess, in the Swank case that we compare with. But anyway, be that what it is, she drank 16 ounces of vodka, sit there, waited for a truck or somebody to show up. Mr. Masik, in his testimony, indicated he would help pull her out. He was just going to finish grading the drive of the gravel. Once that was done, he was going to pull her out. So his testimony was uncontroverted. I mean,
counsel, on that very point, that kind of gets to my question.
Okay.
We've spent a lot of time questioning whether the officer's actions were reasonable or not, but it seems to me there's a previous question, which is, do we still have an outstanding question of fact on whether there was even a DUI here?
I think we do.
So let's say this court finds that the officer's actions were reasonable because of what he knew at the time. What happens to this case? I mean, the lower court never actually reached that factual determination, did it? Or am I not understanding what happened below?
Well, I mean, what I look at is, I think on remand, I think Justice Beyer said that in the Swank case specifically, that this judge had the opportunity to observe the demeanor and presentation of Morrison and Swank on the witness stand, and an opportunity no appellate court can have. They must confine itself to determining whether there is substantial competent evidence to support the judge's ruling.
But did that happen? I mean, that's what I'm asking. What happened below? It seems to me that the court found that the evidence shouldn't have come in because the officer's actions weren't reasonable. Therefore, the lower court didn't even have to address the credibility question.
Right.
Is that right?
Yes.
I presume your perspective would be, even if we lose on the district court's actual ruling, we still get to argue the facts.
Well, I think if you're looking at the judge's decision, he was there and listened to the witnesses and made a decision from it.
Well, that's what I'm trying to figure out is what was the judge's actual decision? Because there's two ways your client could win here, right?
Yes.
You could win on basically what amounts to an evidentiary ruling.
Yes.
They shouldn't have been able to take the test at all.
Right.
Or you could win because the judge believes your client.
He believed there was an intervening alcohol.
Right. That's what I'm asking.
Yes.
Do we know how the district court looked at that question?
I think it did it on the basis of the intervening alcohol. And believe that, and then
the district court did say he was finding in favor of your client because of intervening alcohol consumption.
Yes.
That's the source of my confusion, I guess.
Right. I suppose the judge could have ruled that the officer should have asked more questions or been more reasonable in what his questioning was at the time.
Well, by citing to Swank, that makes it appear that that's what the district court was doing.
Right. Yes.
Counselor, since you paused just a minute, let me carry that a little bit further. Why shouldn't it be up to the trier of fact to make the determination if we have evidence of pre-driving or concurrent driving drinking and post-driving drinking? Why does the officer have to make that determination of which caused the blood alcohol content? You understand what I mean? One beer versus 16 ounces of vodka maybe is extreme enough, but if there was a reasonable belief that there was some drinking before and then some after, we have rates of absorption, we have rates of metabolism, we have a 0.209 is the evidence. Which alcohol was it that caused the 209? Are we going to require officers to be able to do that forensic gymnastics to determine that issue? I mean, as long as there's evidence of drinking before and after, why isn't that just then a trier of fact?
I think that is with the trier of fact, but I do think that she's indicated that it was one beer that she had, and she thought she meant one beer prior to her going into the accident. She's indicating that she didn't know that it was a question after the accident happened, that was the question he was making. And then if you look at his...
Where does that come from? And the officer testified to what he asked, which was how much have you had to drink? She said one beer.
Right.
And you're now saying he thought something else.
She thought.
Or she thought something else.
That's what she thought he was intending by asking how much have you had to drink. That's why she didn't respond to him initially about 16 ounces of vodka.
But the question was reasonable. I mean, it didn't give a time frame. It just said, what have you had to drink? It didn't say, what did you have to drink prior to the accident or after the accident? He specifically asked her. And so based on that information, what's the officer to do?
I understand, but what the officer also in cross-examination indicated that he didn't know what time the accident occurred. He didn't know if the car had been in the ditch for an hour, 2 hours. He said he didn't know, if you look at page 41 and 42 of the transcript, he didn't know that she'd gone to Masick's Body Shop. He didn't know anything about the time. And I think he had a duty to ask a little bit more about, have you been here at the car all the time? Have you been here since the time this accident happened? It's been an easy question.
I asked opposing counsel the same question. Is it? It seems to me there's almost a requirement, at least in your point of view, that intervening alcohol consumption should always be investigated, or nearly always investigated. If not, it defeats the subsequent testing.
I believe it should be asked because there's a lot of other times when you have that kind of lapse of time. Maybe she drank something after she went in the ditch. We have that sometimes where people think they're calming their nerves or whatever the reason is. They drink some afterwards. There wasn't any alcohol in the car, but it was reasonable in that town and that place to think that maybe she, went over to Masick's or went to some place and got some alcohol. That's the only thing is he could have asked a couple of questions. And I think that's what happened in Swank is also the same type of thing. The questions just weren't asked.
Can you help me clarify this issue about the timing and what the evidence is intending to say, how dark it was, and when sunset might have been, to give that approximation of how long it had been?
Well, I'm not sure if the officer really knew exactly what time she went into the ditch. He indicates what time he arrived there, but I don't think we really could establish, and by his cross-examination, he couldn't establish when it happened. And we don't know how much time it took from then, how much time she had from the time she went in the ditch to the time she came back to the vehicle.
What did your client say about darkness, about the curve?
That really wasn't asked of her about darkness or anything else such as that. Oh, as far as the curve, I think she indicated that she didn't see the curve. At one instance, I think that's what she had said, that she didn't see the curve. It was dark or whatever.
On the timeline question, how did the officer get dispatched to the scene? Do we know that?
I believe it was a passing motorist.
So it was not through the same call that got the tow truck there.
My client did not call the police. She called her
A
husband,
private-
or called her husband, and he
Okay.
then got the tow truck, and that was.
And there's no indication that the private parties notified the police.
We don't know who did the calling on this matter. Now, one thing is I need to go into the statute, the unconstitutional statute. Now, I want to say that Jay Norton, who's here in the second case, is the expert on this. I got to say that he had already won his case in front of Judge Moriarty. I took that decision and went in front of Judge Montgomery and said, Judge Montgomery, here's what Judge Moriarty has also said about this also. And like you say, it's dicta. I was quite surprised when I ended up in the Kansas Supreme Court versus over this. I thought I would be in the Court of Appeals, but I guess either way I can end up here either way, and I'm glad to be here. But I'd heard about it. I want to give him the credit for that, because the Meats decision was what I used with Judge Montgomery and arguing that. I mean, as lawyers, we go into these cases, we try to win on the facts, and then also we try to win on constitutionality issues if we can too. So in this case, we had won on the facts, and I don't know why. I really didn't need the constitutionality issue at that point. I didn't think, but I'm not sure. I just believe though that based upon what this court has said in the past regarding district court judges and hearing the facts and things of that nature, that we would be hopeful that that would not be overturned on the issue of the facts. The issue of the Meats decision goes to the Kansas KSA 8-1020A2. May have to pay this $50 fee within 14 days. You don't have any alternative. You don't have any affidavit. And quite honestly, there are people out here who don't have that kind of money. They've used all their money from their paychecks. It's the winter time. They don't have construction work going on. They don't have the $50. They may budget for the insurance and car through the summer and pay for those things, but they may not have $50 at this point. I don't know what the line is. Is it 100? Is it 250? Where is it that we draw the line that people can get help because they don't have the money? And
Is there a due process question because of the non-refundability? In other words, innocent people can be given a DC-27 and they have to pay $50 even if it's shown that it was totally frivolous, that there's no mechanism to return that. Is that, if that's a reasonable amount to pay for the cost of an administrative hearing, is that okay that innocent citizens have to bear that?
I think it's a very good point, Justice Johnson, in that we don't. Sometimes it's hard to get our driver's licenses back, but I don't know if we can get $50 back from the state or not. It might be very difficult to do. We've never tried it. In any case, that we won, but it is interesting that it seems like it's just a fee and it's gone.
What's the point of the fee, from your perspective?
I really do not know. I cannot tell you what the point is.
I mean, if the fee was really to assess cost, there's a very common mechanism for assessing costs after a party loses, I guess is what I'm thinking.
I thought it was maybe a way to produce fees and produce money for the state. I don't know. Because, you know, a lot of our other fees
Well,
have gone
to
up.
Justice Johnson's point, if you want to recoup some costs against guilty parties, you assess court costs or fees after the fact.
Assess it on their driver's license. If next time they come up, it could be a computer thing you put on. Next time your driver's license come up, you appealed this case, here's $50 you got to pay if you want your driver's license. I think that would be a good way to do it.
Besi-
How would that differ on the issue of innocence versus guilt?
You'd have years, maybe a year or 2 year, or the 4 years or 6 years that you have when you get your driver's license. You'd have some time to get that money back. It's just not 14 days is a big problem. Is sometimes the people don't have the money right then.
Well, you have to pay $100 reinstatement fee anyway, don't you?
Yes,
or
you do.
$150 or whatever. So.
You do. SR 22 and quite a bit of few hoops you have to jump
If
through to
it's,
get
if it's a due process violation, it doesn't matter whether the person's a millionaire or a pauper, right?
That's true. That is true.
Besides,
I see my time is up.
besides the Meats case, what is the best case you have to support your position on this issue?
I would have to say that for me, it's the Meats case is what I relied upon to the judge. I'd have to look at the brief that Mr. Norton prepared, and I think would be probably the best way to answer that question.
All right. Did you have a question, Justice Rosen?
No, I'm just fine.
Any further questions? All right. Thank you, counsel.
Thank you.
I would just like to clarify a couple of things. Mr. Woods mentioned something about 2-year suspensions. It's actually just a 1-year suspension at most for a driver's license. And Justice Deagle, to go to your question about what the district court decided based on the witnesses he had in front of him, I would argue that his decision was wrong because he overextended the responsibility of what the officer had to do. He overextended swing. And so even if this court finds that if the court finds that he overextended that, then it probably would have to be remanded for him to decide if the officer's actions were reasonable.
But I understood that you were asking for us to uphold the suspension
Yes.
as opposed to a remand.
Well,
But now you're conceding that maybe you do have to have a remand. Am I understanding
I would say at
correctly?
most there should be a remand for the.
Well, is there any way that we could simply uphold this suspension?
I think this court could find.
How would we do that? Given the lack of the factual finding that I think I just heard you admit to.
Well, I think that. Oh, yes, Your Honor. I think you would probably have to remand it for the district court to reassess the facts that he heard that day based on the reasonableness.
Well, if the district court believes the testimony of the driver and the other witnesses about the vodka and weighs that evidence and concludes that there was no DUI. I mean, that's a possibility here, right?
That's true.
Well, we're talking, the DUI is I mean, what the suspension's based on is the .209.
It's
Right?
it's based on the failure, yes, of the test.
Okay.
And
So I think your answer is that the court still needs to determine whether the failure was driven by the post driving drinking. The court found that he drank, that she went to Basics Body Shop, had a solo cup full of raspberry vodka, but that doesn't end the story. The court has to find that therefore there's no reasonable grounds to believe that .209 was an accurate figure when she was driving, doesn't it?
The statute and the reasonable grounds are all stemming from what the officer, did the officer have reasonable grounds to believe she was driving under the influence? And that's the only question that the judge should determine. But he added this extra layer of creating an unreasonable standard for the officer to complete that night, which is to further inquire, even though it wasn't reasonable for him to do so that evening. Everything is based on what the officer observed or could come to the conclusions of that night. And so I would argue that even if the judge found that she had consumed that alcohol after the accident, that doesn't negate the officer's reasonable grounds to request the test.
I guess I'm just confused. Is it your argument that if the officer had reasonable grounds to conduct the test, that you win?
Yes.
Even if there's overwhelming evidence that she was not intoxicated when she was driving the vehicle?
We win in this circumstance because it wasn't reasonable for him to further investigate the post-driving consumption.
I understand that, and I'll give. Let's just, for the purposes of argument, we give you that.
Mm-hmm.
The officer acted reasonably. Don't you still have to prove that the failed test was failed because of pre-driving or contemporaneous driving drinking?
Your Honor, I don't think that it extends to that.
So the state doesn't actually have to prove that someone was driving while intoxicated.
They have to prove that the officer believed she had been driving while under the influence and that there was a test failure.
But on remand, that's the question before us, and which was what would allow you to win or lose here, determining that question. But on remand, if we remand it and the judge moves past and does introduce the evidence, isn't there still an evidentiary question of whether there's a DUI? I mean, he may determine that the evidence shows that the intoxication was caused by the vodka, not the alcohol she had consumed before she was driving. So that's still a possible outcome of the entire case.
I believe the way that the statute is written, it's what the officer believed that night. And if the judge finds that there's evidence to support that, then...
So you can suspend the driver's license regardless of whether or not there's proof of intoxication at driving.
Once there's a test failure.
Once there's a
right.
test failure.
That's what you're saying.
I'm not sure that I can address that question with any certainty today, other than what I believe the statute, how it's written, would be.
But that question may make a difference in how we would, what direction we would provide the district court on remand.
Mm-hmm. The only way I can answer that, I think, is the reasonable grounds determination is kind of an all-encompassing thought that the officer believes that has been driving under the influence, requests the test. This court would have to determine if he had justification to believe that, and then, if she had refused or failed, that's a separate part of the statute. But what the officer had before him that night to request the test is all this court and the district court needed to determine.
But you can have reasonable grounds to support the test and later find out that the machine was defective or that the officer wasn't paying close attention and the person was not fully cooperating or was involuntarily hiccuping or coughing or sneezing, which we know can affect the results of the test. So why is it that just the reasonable grounds concluded by the officer is enough?
I just think the way that this appeal came forward and that the results themselves weren't challenged. I think that's all this court needs to determine is what the officer had before him before he requested the test.
So if we find that the officer's actions were reasonable
Mm-hmm.
and we have a failed test, under your theory of the case, there is no reason for a remand.
When you lay it that way, yes, I think that's correct.
Then it doesn't seem unfair to put an additional burden on the law enforcement officer to ascertain that there wasn't post-driving driving, do you think? I mean, if the reasonable grounds, test failure, you lose your license, then why shouldn't we require the officer to make certain that the grounds are reasonable, and dissuade or disabuse himself of the idea that there may be some other reason why the test was failed?
I think that Swank gives us some guidance on that, and again puts it in what do the circumstances and his investigation to that point. What does that? What would that come to the conclusion? Like, I'm sorry. It all stems on what is reasonable for the officer to do that night, and I think I'm not arguing that that any officer in any circumstance wouldn't have to ask that question, but based on the circumstances of that night, what he had before him, the facts and circumstances, it was unreasonable for the district court to require him to further inquire. So I would not argue that in any circumstance an officer doesn't have that duty, but based on this court's holding in Swank, reasonableness is key, and based on what he had before him that night.
And so it's based on the facts of this case.
That's
and
right.
The district court found the facts.
The court.
And so why don't we accord deference to the district court's factual findings like we always do?
Because in this circumstance, he overextended Swank and said that if there's any possibility, as in the officer didn't stop the vehicle himself and she wasn't in her car, if there's any possibility of post-driving consumption, then you have to inquire. And I think that does overextend Swank and put on the officer more burden than is necessary.
Counsel, I see you're out of time.
Yes.
Do you need 20 seconds to wrap up, or do you think you've made your points?
I think I've made my points as best I can. I appreciate that. Thank you.
All right, thank you, counsel. Court will take this matter under advisement. We thank both counsel for their arguments this morning.